Imagine finding out that an accident you didn't even have is the reason your insurance company just cancelled your no-claims bonus. You're driving through a wet evening, you turn into a side street, and you never hit a thing. No dent, no scratch, and certainly no collision with a pedestrian. But weeks later, a liability claim lands on your doorstep, your premiums double, and you're suddenly facing a potential fine of up to £5,000. This is the reality for thousands of British drivers who are discovering too late that the definition of an accident has fundamentally changed. In the eyes of the law and your insurer, you can now be held 100% liable for an injury, even if your vehicle never actually touched the person involved. The assumption that "I didn't hit them, so it's not my fault" is officially dead under the current highway code. The biggest problem on UK roads right now isn't just bad driving. It's a massive gap in what people think the law is versus what it actually says. There is a persistent myth that pedestrians only have priority at a junction if they have already stepped into the road. Most of us were taught that as long as the person is still on the pavement, the car has the right of way to complete its turn. But that rule is gone. Under the current highway code, particularly Rule H2, you are legally required to give way to pedestrians who are simply waiting to cross the road you are turning into or out of. You don't have to wait for them to step out. Simply standing at the curb ready to cross is enough to shift the legal burden onto you. This isn't just a theoretical change for a theory test. It is being used by insurance companies right now to decide who pays after a near miss. Take the case of James, a driver from Leeds with over a decade of clean driving history. One evening, he turned left into a side street where a woman was standing on the corner, waiting to cross. James assumed she'd wait for him to finish his turn, but she stepped forward, had to lunge back to avoid his car, and injured her wrist in the process. Despite the fact that James never touched her, his insurer treated his failure to give way as clear evidence of negligence. James ended up paying an increased excess and watched his premiums skyrocket at renewal because he breached a rule he didn't even know had changed. The financial stakes get even higher when a simple mistake at a roundabout turns into a medical claim. Sarah, a 58-year-old driver in Bristol, was approaching a mini roundabout when she saw two pedestrians waiting to cross her intended exit. She proceeded without slowing down, assuming they would wait for a gap. One of the pedestrians stepped back suddenly to avoid her car, tripped, and injured their hip on the curb. Because the hierarchy of road users places the greatest responsibility on those who can do the most harm, Sarah's insurer accepted liability for the pedestrian's medical costs and time off work. The result was a massive jump in her next premium and a recorded at-fault claim that will stay on her insurance record for approximately 5 years. So, what is the secret knowledge that could save you from a 5-figure insurance disaster? It comes down to 2 specific sections of the highway code that insurers now lean on: Rule H2 and Rule 170. Rule 170 is explicit. You should give way to pedestrians waiting to cross the road you are turning into. But there's an even deeper layer of liability hidden in the hierarchy of road users. This framework ranks road users based on their vulnerability, placing pedestrians at the very top and HGVs at the bottom. It establishes a legal expectation that those in charge of a vehicle must do everything reasonably possible to avoid danger, even if another road user makes a mistake. If you fail to follow this hierarchy, insurers can use that breach as evidence of fault in court, turning a near miss into a legally established act of negligence. This shift in priority serves as a stark warning for everyone on the road, but the risks look very different depending on which side of the windscreen you're on. For drivers, the consequence is financial and legal. Fines up to £5,000 and the loss of a no-claims discount that may have taken years to build. For pedestrians, the code offers new protections, but it also carries a warning. Your rights only protect you if the driver actually knows you are there. The updated rules advise pedestrians to cross only where they are visible to drivers and to remain fully aware of their environment, explicitly telling them to avoid unnecessary distractions like talking on a phone or wearing earphones. Liability isn't always one-sided. Courts still look at contributory negligence, meaning a pedestrian who steps out without looking could still share the blame. Ultimately, these changes are about more than just who stops first at a side street. They represent a fundamental reframing of how we share public space. If 7 out of 10 drivers are still failing to follow these junction rules, as a 2025 study suggests, then we are all participating in a system where the legal reality has outpaced our daily habits. Are we ready to accept that the responsibility for safety lies most heavily on those with the most power? Or are we going to wait for an insurance claim to teach us the new rules of the road? The lesson is simple. At every junction, pause and check for the person waiting at the curb, not just the one already in the road. This isn't just about being polite, it's about protecting your license and your livelihood in a world where no contact no longer means no fault. Thanks for watching The Law Desk UK. If you found this helpful, subscribe for a new video every week and leave any questions in the comments. See you next time.